Amendment 1. Freedom, religion, speech, press, assembly, and petition. Passed by Congress September 25th, 1789. Ratified December the 15th, 1791. The first 10 amendments form the Bill of Rights. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, all of the press, or the right of the people peaceably to assemble and to petition the government for the redress of grievances. What is the... Sorry. Let me go to the first clause. That's going to be the establishment clause. Common interpretation by Marcy E. Hamilton and Michael McConnell. Americans' early settlers came from a variety of religious backgrounds. Puritans predominated in New England, Anglicans predominated in the South, Quakers and Lutherans flocked especially to Pennsylvania, Roman Catholics settled mostly in Maryland. Presbyterians were most numerous in the middle colonies, and there were Jewish congregations in 5 cities. During colonial time, the Church in England was established by law in all of the southern colonies, while the localized Puritan or Congregationalists establishments held sway in most New England states. In those colonies, clergy were appointed and disciplined by colonial authorities, and colonists were required to pay religious taxes and often to attend church services. Dissenters were often punished for preaching without a license or refusing to pay taxes to a church they disagreed with. Delaware, New Jersey, Pennsylvania, Rhode Island, and much of New York had no established church. After independence, there was a widespread agreement that there should be no nationally established church. The Establishment Clause of the First Amendment, principally authored by James Madison, reflects this consensus. The language of the Establishment Clause itself applies only to the federal government. Congress shall pass no law respecting establishment religion. All states established religion by 1833, and in 1940s, the Supreme Court held that this establishment applied to state governments through the 14th Amendment. Virtually all jurists agreed that it would violate the Establishment Clause for the government to compel attendance or financial support of religious institutions as such, for the government to interfere with the religious organizations' selection of a clergy or religious doctrine, for religious organizations or figures acting in a religious capacity to exercise governmental power, or for the government to extend the benefits to some religious entities and not others without adequate secular justification. Beyond that, the meaning of the amendment is often hardly contested, and established cases in the Supreme Court often lead to 5-4 splits. The Lemon Test. In 1971, the Supreme Court surveyed its previous Establishment Clause cases and identified 3 factors that identify whether or not a government practice violates the Establishment Clause. First, the statute must have a secular legislative purpose. Second, its principal or primary effect must be one that neither advances or inhibits religion. Finally, the statute must not foster excessive entanglement with religion. Lemon versus Koosman, 1971. In the years since Lemon, the test has been much criticized, and the court often decides established clause cases without without reference to it. Yet the justices have not overruled the layman test, meaning the lower courts remain obliged to use it. In some specific areas of controversy, however, the court has adopted a specific, more targeted test to replace layman. The vast majority of Establishment Clause cases have fallen in 4 areas: monetary aid to religious education, other social welfare activities conducted by religious institutions, government-sponsored prayer, accommodation of religious dissenters from generally applicable laws, and government-owned or sponsored religious symbols. Scholars have long debated between 2 opposing interpretations of the Establishment Clause. It applies to government funding. One, that the government must be neutral between religious and non-religious institutions that provide education or other social services. And 2, that no taxpayer funds should be given to religious institutions if they might be used to communicate religious doctrine. Initially, the court tended towards the first interpretation. In the 1970s and the 80s, the court shifted to the second interpretation, and more recently, the court had decisively moved back to the first idea. After two early decisions upholding state statutes, allowing students who attend private religious schools to receive transportation, Everson was board education, 1947, and textbook subsidies available to all elementary and secondary students, board education versus LM, 1968. The court attempted to, for about 15 years, to draw increasingly sharp lines against the use of tax-funded assistance for the religious aspects of education. At one point, the court even forbade public school teaching specialists from going on the premises of religious schools to provide remedial assistance. Angler versus Fulton, 1985. More recently, the court has upheld programs that provide aid to educational or social programs on a neutral basis only as a result of the genuine and the independent choices of private individuals. Zellman versus Simons Harris, 2002. Indeed, the court has held that it's unconstitutional under free speech or free exercise principles to exclude otherwise eligible recipients from government assistance solely because their activity is religious in nature. Rosenberger versus University of Virginia, 1995. Government-sponsored prayer. The court's best-known Establishment Clause decision held it unconstitutional for public schools to lead school children in prayer or Bible reading, even on an ostensibly voluntary basis. Eagle versus Whitehall, Whitehall, I think that's how to pronounce it. 1962, Abington School District versus Skimp. 1963. All of those decisions were highly controversial among the around the public, less so among scholars. The court has not backed down. Instead, it has extended the prohibition to prayers and graduation ceremonies. Lee versus Wiseman, 1992. And football games. Santa Fe Independent School District versus Doe, 2000. In less coercive settings involving adults, the court has generally allowed government-sponsored prayer. Marsh versus Chambers, 1983, the court upheld legislative prayer, specifically because it was steeped in history. More recently, the court approved an opening prayer or settlement and town council meetings, where the town represented that it would accept any prayers of any faith. Town of Grace versus Galloway, 2014. Accommodation of religion. Hundreds of federal, state, and local laws exempt or accommodate religious believers or institutions from otherwise neutral, generally applicable laws for whom compliance would conflict with religiously motivated conduct. Examples include military draft exemptions, kosher, halal meals for prisoners, medical neglect exemptions for parents who do not believe in medical treatment for their ill children, exemptions from some anti-discrimination laws for religious entities, military headgear requirements, and exemptions for the sacramental use of certain drugs. The Supreme Court has addressed very few of these exemptions, while the court held that a state sales tax exemption limited to religious publications was unconstitutional in Texas Monthly in Corporation versus Bullock, 1989. It unanimously upheld the exemptions of religious organizations from prohibitions on employment discrimination for ministers. Hosanna-Tabor Evangelical Lutheran Church and School versus EEOC, 2012. Two federal laws, the Religious Freedom Restoration Act, RFRA, and the Religious Land Use and Institutionalized Persons Act, RLUIPA, provide broad-based statutory accommodations for religious practice when in conflict with the federal and certain state local laws. The unanimous court upheld this approach for prisoners against a claim that granting religious accommodations violates the Establishment Clause, reasoning that RLUIPA alleviates exceptional government-created burdens on private religious exercise in prisons. Carter versus Wilkerson, 2005. The court in Carter left open the question whether such a regime applied to land use is constitutional. It has also left open the possibility that even some applications in prisons may be unconstitutional if they are not even-handed among religions or impose too extreme a burden on non-believers. The court's recent 5-4 decision in Burwell versus Hobby Lobby Stores Incorporation, 2014, held that RFRA exempt for-profit employers from paying for insurance coverage for conceptive drugs that they believe are abortion-inducing, has reinvigorated the debate over such laws. Government-sponsored religious symbols. The cases involving governmental displays of religious symbols, such as the Ten Commandments, display in public school classrooms, courthouses, or public parks, nativity scenes in courthouses and the shopping district, or crosses on public land, have generated much debate. The most prominent approach in more recent cases is called the endorsement test. It asks whether a reasonable observer acquainted with the full context would regard display as a government endorsing religion, and therefore sending a message of disenfranchisement to other believers or non-believers. The court decisions in this arena are often closely divided. They also illustrate that the court had declined to take a rigid, absolutist view of the separation of the church and the state. In Leach versus Donnelly, 1984, the court allowed display of nativity scenes surrounded by other holiday decorations in the heart of a shopping district, stating that it engendered a friendly community spirit, goodwill, in keeping with the season. But in County of Allegheny versus American Civil Liberties Union, 1989, a different majority of justices held that the display of a nativity scene by itself at the top of the grand stairway in a courthouse violates the Establishment Clause because it was indisputably religious, indeed sectarian. In McCreary County versus American Civil Liberties Union, 2005, the court held that a prominent display of the Ten Commandments and the county courthouse, which was preceded by an official description of the Ten Commandments and the embodiment of ethics in Christ, was a religious display that was unconstitutional. The same day it upheld the Ten Commandments monument, which was decorated by a secular organization dedicated to reducing juvenile delinquency and surrounded by other monuments on the spacious State House grounds, Van Orden versus Perry, 2005. Only one justice was in the majority in both cases. More broadly, the Establishment Clause provides a legal framework for resolving disagreements about the public role of religion in our increasingly pluralistic republic. Matters of debate. The first perspective, the Establishment Clause, a check on religious tyranny by Marcy E. Hamilton. Accurate recounting of history is necessary to appreciate the need for disestablishment and the separation between church and the state. The religiosity of the generation that framed the Constitution and the Bill of Rights, which the First Amendment is the first and the result of a historical accident, not the preference for religious liberty over any other right, has been overstated. In reality, many of the framers and the most influential men of that generation rarely attended church, were often deist rather than Christian, and had a healthy understanding of the potential for religious tyranny. This land concerns to be expected, as European history was awash with executions of religious heretics, Protestant, Catholic, Jewish, and Muslim. Three of the most influential men in the framing era provided valuable insights into the mindset and the time: Benjamin Franklin, James Madison, and John Adams. Franklin saw a pattern. If we look back into history for the character of the present sects in Christianity, we shall find few that have not in their turns been prosecutors and complainers of persecution. The primary Christian sought persecution extremely wrong in the pagans, but practiced on one another. The first Protestant church in England blamed persecution in the Romish church, practiced upon the Puritans. Those found it wrong in the bishops, but following the same practice themselves, both here in England and in New England. Benjamin Franklin, letter to the London Packet, January the 3rd, 1772. The father of the Constitution, the primary drafter of the First Amendment, James Madison, in his most important document on the topic, Memorial and Remonstrance Against Religious Assessments, 1785, stated, during almost 15 centuries, as the legal establishment of Christianity being on trial, what has been its fruits, more or less in all places: pride, indolence in the clergy, ignorance and servility in the laity, in both superstition, bigotry, and persecution. What influence, in fact, have ecclesiastical establishment had on society? In some instances, they have been seen to erect a spiritual tyranny on the ruins of civil authority. In many instances, they have been seen upholding the thrones of political tyranny. In no instance have they been the guardians of the liberties of the people. 2 years later, John Adams described the states as having been derived from reason, not religious belief. It will never be pretended that any persons employed in that service, at any interviews with the gods, or were in any degrees under the influence of the heaven, any more than those at work upon ships or horses, or laboring in the merchandise or agriculture, will forever be acknowledged that these garments were contrived merely by the use of reason and the senses. 13 garments of the original states, thus founded on the natural authority of the people alone, without the pretense of miracle or mystery, which are destined to spread over the northern part and then the whole quarter of the globe, an agreed point again in favor of the rights of mankind. The works of John Adams, second President of the United States, Volume 4, 292 to 93 pages. Charles C. Letter and James Brown. Edition, 1851. Massachusetts and Pennsylvania, an example of early discord. In Massachusetts, Congregationalists establishment enforced taxation on all believers and expelled or even put to death dissenters. Baptist clergy became the first in the United States to advocate for the separation of church and state and an absolute right to believe when one chooses. Baptist pastor John Leland was an eloquent and forceful proponent of the freedom of conscience and the separation of church and the state. For him, America was not a Christian nation, but rather should recognize the equality of all believers, whether Jews, Turks, pagans, or Christians. Government should protect every man in thinking and speaking freely and see that one does not abuse another. He proposed an amendment to the Massachusetts Constitution in 1794 because of the evils occasioned in the world by religious establishments and to keep up the proper distinction between religion and politics. Pennsylvania, damned the holy experiment by founder William Penn, was politically controlled by Quakers who advocated the tolerance of all believers and the mutual coexistence of different faiths, but who made their Christianity a prerequisite for public office, only permitted Christians to vote, and forbade works on the Sabbath. Even so, the Quakers set in motion a principle that became a mainstay in religious liberty jurisprudence. The government may not coerce citizens to believe what they are unwilling to believe. If one looks carefully into the history of the United States religious experiment, one also uncovers a widely shared view that too much liberty or licentiousness is as bad as no liberty, according to historian John Philip Reed. Those in the 18th century, and as agreed, a duty to oppose licentiousness and to defend liberty. Established Clause Doctrine. The Established Clause has yielded a wide array of doctrines, legal theories articulated by courts, each of which is largely distinct from the others, some of which are described in Professor McConnell's and mine joint contribution on the Established Clause. The reason for this proliferation of distinct doctrines is that the Established Clause is rooted in a concept of separating the power of church and the state. These are the two most authoritative forces of human existence, and drawing a boundary line between them is not easy. The further complication is that the exercise of power is fluid, which leads both state and church to alter the position to gain power, either one or the other, or as union in opposition to the general public or particular minorities. The separation of the church and state does not mean that there is an impermeable wall between the two, but rather that the framers fundamentally understood that the union of power between church and state would lead inevitably to tyranny. The established churches of Europe were well known to the founding era, and the framers undoubtedly contributed to James Madison's inclusion of the Established Clause in the First Amendment and its ratification. The following are some of the most important principles. The government may not delegate governing authority to religious entities. The court has been sensitive to incipient establishments of religion. Massachusetts law delegated authority to the churches' schools to determine who could receive a liquor license within 500 feet of their buildings. The Supreme Court struck down the law because it delegated to churches zoning power, which belonged to state and local government, not private entities. Larkin versus Randall's Dean Incorporation, 1982, according to the court, the law substitutes the unilateral and absolute power of a church for the reasoned decision-making of a public legislative body on issues with significant economic and political implications. The challenge stands to enmesh churches in the process of government and creates the danger of political fragmentation and divisiveness along religious lines. In another scenario, the Supreme Court rejected attempt to define political boundaries solely according to religion. In Board of Education for Kiryas-Jo Village School District versus Grummet, 1994, the city of New York designated the neighborhood boundaries for Satmar Hasidim Orthodox Jews in Kiryas-Jo Village as a public school district itself. This boundary was determined solely by religious identity, in part because the community did not want their children to be exposed to children outside the faith. The court invalidated the school district because political boundaries, identified solely by reference to religion, violate the Establishment Clause. There is no such a thing as the church autonomy, although there is a doctrine that forbids the courts from determining what religious organizations believe. Recent years, religious litigants have asserted a right to church autonomy, that churches should not be subject to governmental regulation in a wide variety of cases, and particularly in cases involving the sexual abuse of children by clergy. The phrase, however, is misleading. The Supreme Court has never interpreted the First Amendment to confer on religious organizations a right to autonomy from the law. In fact, in the case of which how most recently demanded such a right, arguing religious ministers should be exempt from laws prohibiting employment discrimination. The core majority did not embrace the theory, not even using the term once. Hosanna Nash Tambor Evangelical Lutheran Church and the School versus EEOC 2012. The courts are forbidden, however, from getting involved in determining what the religious organization believes, how it organizes itself internally, or who it chooses to be ministers of the faith. Therefore, if the dispute brought to a court can only be resolved by a judge or jury settling an intra-church ecclesiastical dispute, the dispute is beyond judicial consideration. This is a corollary to the absolute right to believe what one chooses. It is not right to be above the laws that apply to everyone else. There is extraordinary slippage in legal beliefs in numerous cases where the entity is arguing for autonomy. But what they really mean is freedom from the law, per se. For the court, the basic common sense, these arguments for placing religion above the law and in violation of the Establishment Clause. They are also fundamentally at odds with the common sense of the framing generation and understood so well the evils of religious tyranny. Next perspective, the Establishment Clause, co-guarantor of religious freedom, by Michael McConnell. The Establishment Clause of the First Amendment, Congress shall pass no law respecting an established religion, is one of the most misunderstood in the Constitution. Unlike most of the Constitution, it refers to a legal arrangement, the establishment of religion, which has not existed in the United States in almost 2 centuries. We understand what freedom of speech is, we know what private property is, and we know what the searches of Caesars are, but most of us have no familiarity with what an established religion would be. The church by law established in Britain was a church under control of the government. The monarch was and is the supreme head of the established church and chooses leadership. Parliament enacts its articles of faith. The state composes or directs the content of its prayers and liturgy. Clergy have to take an oath of allegiance to the king or queen. And not surprisingly, the established church was used to inculcate the idea that British subjects had religious as well as a civic obligation to obey royal authority. The established church was a bit like a government control press. It was a means by which the government could mold public opinion. British subjects, including Americans in 8 of the colonies, were legally required to attend and financially support the established church. Ministers were licensed or selected by the government, and the content of the church services are partially dictated by the state. The established religion was banned for liberty, and it was banned for religion too. It was opposed by a coalition of the most fervently evangelical religious sects in America, especially the Baptists, who saw the hand of government was a pointer to genuine religion. Joined by the Enlightenment and often deist elite like Thomas Jefferson and Benjamin Franklin, who saw church and state should be separate, and by the leadership of minority religions who worried that government involvement would disadvantage them. Accordingly, there were virtually no opposition to abolishing establishment religion at the national level. Establishments swayed for a while in a few states, but the last state, Massachusetts, ended its establishment in 1833. The abolition of establishment for religious entails a number of obvious and uncontroversial elements. Individuals may not be required to contribute to, attend, or participate in religious activities. This must be voluntary. The government may not control the doctrine, liturgy, or personnel of religious organizations. This must be free of state control. Other issues are harder. For a few decades between the late 1960s and the early 1990s, the Supreme Court attempted to forbid states to provide tax subsidies to schools that teach religious doctrines along with ordinary secular subjects. Most of these schools were Roman Catholic. This effort was largely based on a misinterpretation of history egged on by residual anti-Catholicism. The justice said that the mutual aid to schools is just like the 1785 effort to force Virginians to contribute to the church of their choice. The analogy, however, made little sense. There is all the difference in the world between founding churches because they inculcate religion, founding schools because they provide education. In fact, the history of the early republic shows that the states and later the federal government, during Reconstruction, funded education by subsidizing all schools on a non-discriminatory basis. No one ever said this violated the non-establishment principle. By 2002, in Zellman versus Simons and Harris, the Supreme Court returned to this original idea, allowing the government to fund the schools on a neutral basis so long as the choice of religious schools was left to voluntary choice. Not only was ruling this true to history, it also best serves the ideal of religious freedom, making it possible for families to choose the type of education they want for their children. Sometimes suggested as law making special accommodation for people whose religious beliefs are at odds with government policy violate the established clause, on the theory that these accommodations privilege or advance religion. This is the recent mediated idea and a non-sensible one. In all cases of accommodation, the religion involved is descending from prevailing policies, which means, by definition, that the religion is not dominating society. The idea that making exceptions for the benefit of people whose beliefs conflict with the majority somehow establish religion is a plain distortion of the words. And the Supreme Court has unanimously held that religious accommodations are permissible as long as they lift the governmental obstacle to the exercise of religion, take account of cost to others. I do not favor one face or another. Nonetheless, when religions take unpopular stances on hot-button issues, for example, regarding abortion, inducing contraceptive, or same-sex marriage, critics are quick to assert that it violates the Constitution to accommodate their differences, no matter how little support that position has in history or Supreme Court precedent. The fundamental error is to think that the Establishment Clause is designed to reduce the role of religion in American society. A better understanding is captured in the statement of Justice William O. Douglas of the Supreme Court this country sponsors attitudes on the part of government that shows no partiality to any one group, and that lets each flourish according to the zeal of its adherents and the pure of its dogma. That's the end of this clause.